The
hearing.
counsels on behalf of petitioner numbers 1, 2, 3. So we have.
But it is the court's direction to club the petition.
Shall I proceed? Much obliged. Honorable Bench, the first issue that comes in front of this court is whether Mackenzie is entitled to compassionate appointment and compensation posthumously awarded to Champagne. We are representing the first petitioner, that is Mahila Samaj Kalyan, who is on behalf of Mackenzie for the first issue. And for issues 2 and 3, we are representing 2, 3 and 4, we are representing petitioners 2 and 3. Much obliged. The counsels for petitioner number 1 humbly submit that Mackenzie, being the lawfully wedded wife of Champagne, is eligible for the above. Coming to the first sub-issue, there is a presumption of marriage that exists between Mackenzie and Champagne. The counsel requests the Honorable Bench to refer to paragraph 7 of the Moot Court proposition, wherein it states that Mr. Champagne, who belonged to a tribal community, married Mackenzie by elopement in 2020. They lived a secluded life in a separate village with their 3-year-old child Emerson. Honorable Bench, scheduled tribes are excluded from the purview of Section 2, Subsection 2 of the Hindu Marriage Act unless otherwise determined by the central government. Page 32 of Volume 2 of our compendium reads that notwithstanding anything in Subsection 1, nothing contained in this Act shall apply to the members of any tribal communities with the meaning of Clause 25 of Article 36 of the Constitution unless central government by notification in the official gazette otherwise specifies. Honorable Bench, it is submitted that this provision specifically permits, or rather, to follow their customary law for matters of marriage unless they have evidently renounced their unique customs. In furtherance of the same, the counsel. Honorable Bench, since these tribal populations are allowed to govern their own judicial, executive and legislative autonomy altogether, which the council will deal in the furtherance of the issues, I shall establish the same as well. Shall I proceed? In furtherance of the same, the council submits that they got married in secrecy. Honorable Bench, the custom dealt with in this instant matter is that of Rakshasha Vivaha, which is widely practiced in tribal communities. This submission is not just by the council himself, but it was reiterated in the Supriyo versus Union of India case of 2023, where the Supreme Court stated that in order to prevent illegitimate unions, our sages have always followed Rakshasha Vivaha. This is present in page 835 of volume C of our compendium as presented. It is also an undisputed fact that after the marriage in 2020, Champagne and Mackenzie lived in a secluded life in a secluded village till 2024. Under section 119 of the Bharatiya Sakshi Adhiniyam, long cohabitation and reputation corroborate the presumption of a valid marriage. This is done to preserve the sanctity and stability of marital institutions in Himvarsha. Coming to the second sub-issue, if the council is able to satisfy the contents of the first sub-issue, we would like to submit that the state or the judiciary cannot give recognition to a second marriage ex debito justitiae while the first marriage was subsisting. The council would request the Honorable Bench to refer to paragraph 8 of the Moot Court proposition, wherein it states that under the impression that Champagne is still unmarried, he was made to perform levirate marriage with Shera Seema. The custom of marrying a dead brother was to preserve the family so that the children born out of the marriage could be considered as those of the deceased brother. However, levirate marriage presupposes or states that such brother must be unmarried. Furthermore, the consent should have been free and fair, none of which were the case here. The council will also submit that as per paragraph 6 of the proposition, Champagne and his family are strongly presumed to belong to the Mengdo tribe. Now we would state why that is the case. Because levirate marriages are inherently patriarchal, and thereby the custom that was followed by Champagne's family indicates their affiliation with the Mengdo tribe. Furthermore, as per paragraph 6 of the proposition, it is also stated that the Mengdos who have adopted a patriarchal system due to their conversion to Christianity, thereby, Honorable Bench, the Mengdos were converted Christians. It is submitted that tribes are allowed to preserve their customs despite conversion. However, statutory mandates must apply to them. Bigamy is neither preferred nor allowed under the Christian Marriage Act of 1872 or the Special Marriage Act, section 44 of the same of 1954. Champagne's second marriage thereafter was void ab initio. Furthermore, the public policy of the state prohibits polygamous relationships, Thereby, the second marriage cannot be held valid. Now, this is not, again, not just the council submission, but even before the commencement of the Uniform Civil Code in 2024, such acts were punishable under the Indian Penal Code of Section 494, which is presently the Bharatiya Nyaya Sanhita, Section 82, which is present in. Yes, Honorable Bench.
Uniform Civil Code have retrospective operation, or should the operation be restricted to only those marriages and inheritance that take place after the coming into the force of the legislation?
That is something that the councils would like the court to reiterate as well in the
You
prayer
could
that we
do
will
it straight
see.
away so that the issue.
It should not have a retrospective effect, the council believes. And thereby there should be a prospective effect that should be followed, essentially. Honorable Court, the state providing concession to such a second marriage while depriving the first wife would contravene the public policy against polygamy. It is further submitted that a state-sanctioned disadvantage, like a discretionary practice of compassionate appointment, cannot be allowed on grounds which are not just, fair, and reasonable. Now, such a state-sanctioned concession established by law must follow the test of narrow classification. Under this doctrine, Mackenzie and a minor son qualifies the impugned class. This is also reiterated in the Sale versus Madhusudan Das case of 2008, page 624, paragraph 15 of volume 1B of the compendium, which states that appointment on compassionate ground cannot be claimed as a matter of right. It must be provided in the rules. The criteria laid down, therefore, is meant to provide for a minimum relief when the sole breadwinner of the family dies, and thereby that has to be established as well, which we too shall establish in due time. Honorable Court, it is submitted that Mackenzie was the lawfully married wife of Champagne. Thereby, she is also benefited, or rather entitled to the benefits under the doctrine of legitimate expectation. Because there must be predictability, regularity, certainty, and transparency when it comes to state actions.
No, I just have another question, Counsel.
Yes, Honorable.
Can a compassionate appointment be given to a dependent who may not necessarily be the legal heir? Under the Workman Compensation, Motor Vehicle Accidents Act and all that, the reliefs are not restricted only to legal heirs. They are also given to dependents. So can we say that the appointment to the second wife comes in the category of appointment to a dependent and therefore it's not bad?
Honorable Bench, if we were to consider them as dependents as well, why was the first wife not given the same? She was perhaps to be considered first, and later on Shira Sema, and which will also establish why she should have been given preference.
No, from the fact of the
Yes.
case, that was a secret marriage. Nobody knew about it. So, probably the appointment was
Yes.
made on a belief that I am not disputing the validity of the first marriage. But the person who was given an appointment will come under the category of a dependent, right? So can it be restricted? If it is an absolutely discretionary thing.
Honorable Bench, we must also go back to the facts of the case, para 7 of the same,
Okay.
wherein it stated that Mackenzie's claim would be further substantiated by the presence of the 3-year-old minor son, Emerson. Thereby, the absence of consummation or the birth of an issue out of the second marriage.
Marriage was not registered at all.
Honorable Bench, the UCC asks the marriages to be registered. However, that came forward in 2024. The marriage that took place between Champagne and even in the
On that may be out of a given relationship.
yes.
In other words, I'm just exemplifying his question further. Can you discriminate against the so-called illegitimate divorce?
Yes. Honorable, yes.
Fault of the child.
Precisely, Honorable Bench. When it comes to children as well, even if they were to come out of an illegitimate relationship altogether, or a live-in relationship for that matter, the courts have time and again stated that the presumption of legitimacy must be given, or rather given preference when it comes to such cases, rather than presumption against the valid marriage or legitimacy of the same. Thereby, the child will come into play, and thereby Mackenzie and her minor son. Yes, Honorable Bench. Precisely. Precisely, Honorable Bench. Furthermore, Honorable Bench, Mackenzie and her son would become destitute after the passing of the sole breadwinner of the family, However, we know as per the undisputed facts that Shera Sema was living with the joint family of Shempeng. Thereby, she would have other people to take care of her. Now, Mackenzie was living in a secluded village, a secluded life with a son and her husband before he left her. So, thereby, the immediate means of subsistence is that for the council state. Furthermore, Honorable Bench, that is, we shall come to it in our prayer, Honorable Bench. However, if the court so deems fit, they may pass an order that will ask the state to provide a compensation to Mackenzie as well. We do not contend the Shera Sema should not absolutely perhaps not receive it. If so required, she must. However, Mackenzie must be given the first preference in so regards.
Or go one step ahead and say, all right, we have given the appointment to the so-called give one more.
Yes. If the Honorable Court so deem fit, most definitely.
Can public appointments be doled out like that?
Not really, Honorable Bench, but if the need so requires, compassion appointment, it's not a right. It is a rule which has been established. If after consideration of due facts, after consideration of the rules present, if the court so deem fit, as the council wanted to clarify, they may do so.
But in that,
As a matter of economic reality
Yes.
of modern societies, is the function of the judiciary only to allocate according to rights? Can judiciary create wealth?
No, Honorable Bench.
Suppose the entire society decides to go bankrupt. Can the judiciary mandate creation of economic wealth?
No, Honorable Bench.
Whatever is there, they can decide.
Yes.
They can divide.
Yes.
So therefore, if either the earlier lady or the later lady may be entitled, that's a matter for decision. But if one is entitled, can you double the amount instead of 50 lakhs, give 100 lakhs? Yeah, rest of the 50 lakhs should come out of the judiciary's budget.
Honorable Bench, to answer this question that has fallen out of the bench, we would like to say that that was the state's responsibility to ensure that they conducted proper checks to ensure who was to receive the compassionate appointment. Their failure to do so should not take away this right of Mackenzie. She should not be bereft of this right. That should have been the compassionate appointment or the compensation. She lost her husband as well. Her child lost his father as well. So they should not be bereft of this very right of theirs.
One more question, if you please.
Much obliged.
One of your arguments says that the other lady, brother's wife,
Yes.
brother's widow, she's also dependent. Maybe she's also entitled on a compassionate basis. Are you founding or resting your case on right or equities?
Honorable
If
Bench.
it is right, equities have no place.
Yes.
Even assuming that the tribal lady with whom the deceased eloped
Yes.
and lived together, constituting a marriage according to the tribal customs, was well off. If she's entitled, she's entitled. Unless she is disentitled under the law of compassionate, under the regulation of compassionate appointment. But where do equities have a place?
Yes.
Would inviting the judiciary and drawing the judiciary into the vortex of equitable adjustment be doing disservice to the institution of the judiciary when the claim is predicated on rights? Why do you want to draw the
Yes.
judges into making policy choices?
Yes. If I may answer the questions. Firstly, Honorable Bench, we are not seeking it on the matter of right, but equity, because compassionate appointment, as stated, it's
Compassionate appointment is the discretion of the
Yes.
employer,
yes.
state. They may not give. If they give, they have to give it according to Article
Yes.
14. That's a
Yes.
different matter. That's not the equitable part. Your claim is based on a right
Yes.
that you belong to, have a particular status. That's a right, is it
Yes.
not? Once the discretion is used by the state in allocating funds for compassionate appointment and frames rules as to who is entitled, subject to a constitutional challenge to the validity of those rules on equality grounds, the right of a claimant to claim the benefit is a right base, not an equity based. You can't say that officer doesn't like my face, therefore he need not give compassion. That's not how it works, is it not? Even if you are ugly to the perception of that officer, you are entitled to be,
yes.
you have a right to be granted. That's the right part.
Yes.
The discretion part is in the policy making of compassionate appointment. That's the distinction I wish to make.
Shall I proceed? Much obliged. Now I shall proceed with the submission for issue 2 on behalf of petitioner numbers 2 and 3, that is the Tribal Wellbeing Association and the Islamic Personal Law Board, which asks whether the Uniform Civil Code is constitutionally valid and aligns with the fundamental rights. Honorable Bench, the Council humbly submits that the adoption and enactment of a Uniform Civil Code. Yes, Honorable.
Uniform Civil Code is constitutionally valid and aligned with the fundamental rights. That's how the issue has been articulated here
Yes.
at the end. Now, my understanding is that Uniform Civil Code is in furtherance of the directive principles of the state policy,
yes.
which are mentioned in the Constitution
Article
itself.
44.
I mean, do you have to harbor so hard on this issue?
This issue was provided to us in the proposition itself, Honorable Bench.
Okay, therefore
Thereby we
you are
are-
doing
yes.
it. Huh?
Yes.
So if there is a mistake, we'll stick to the mistake. Huh?
We will perhaps address this very issue in the ongoing issue if the court may so allow us.
No, I mean,
Yes,
had I been a counsel there, I would have argued that this issue is unnecessary, redundant,
Fair.
and irrelevant.
Fair, Honorable Bench.
Okay, you concede that. Fair enough. Go ahead. Yeah.
Honorable Bench, the Council humbly submit that the Constitution of Himvarsha grants a special status and right to self-determination to the scheduled tribes. That is under Schedule 5, Part B, Entry 5 of the same, which states, the Council shall read it out, that laws applicable to scheduled areas, the Governor may by public notification direct that any particular act of Parliament or of the legislature of the state shall not apply to a scheduled area because they work in advice of the Tribal Advisory Council. Honorable Bench, this exclusion, they have been excluded from the ambit of personal laws as well, tribal areas, because even the Bharatiya Nagrik Suraksha Sanhita excludes the tribal areas from its purview. It's further submitted that only laws as defined under Article 13 may be declared unconstitutional for violating Part 3 of the Constitution. It is further submitted that laws in force before the commencement of the Constitution refer only to statutory or codified laws which were enacted by the legislative bodies. And our personal laws or tribal customs are uncodified. Tribal customs do not fall under this definition and thereby must be excluded from the scrutiny of fundamental rights violations. Customs or religious beliefs have been existing from time immemorial and thereby they cannot be subjected to tests of rationality. We further seek the leave of this court to elucidate the true nature of Article 44 of the Constitution. It is submitted that DPSPs are non-enforceable in nature. The Council submit that Article 44 indicates a uniform policy rather than a common law which was enacted in this case. If I may read it out, it states that the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Two things, Honourable Bench. First, that the proper noun was used, or rather the proper noun was not used. The terms uniform civil code, the letters U, C and C are in small letters, which indicates, or rather the absence of these capital C and capital U indicates that the expression only prescribes a policy principle and not a common comprehensive law. Furthermore, as it is stated that the
On what basis you have drawn this conclusion?
Honorable Bench, this is drawn, we have our resources for the same which we have cited in the compendium. Furthermore, if the legislative intent,
Whatever you have quoted, that is all right, but for our knowledge, you
Yes.
must say you.
most definitely, if I may clarify the same, it is firstly, Honorable Bench, the very line that the state shall endeavour, I'll deal with that and then I'll particularly answer your question. The state shall endeavour, as stated in this provision of that, or rather the article. And therein after, it's not stated that the state shall implement. Realization of any, yes, realization of a constitutional principle, Honourable Bench, is interpretation specific and not case specific.
Why don't you read the article for this article along with Article 37 of the Constitution?
Yes, Honourable Bench.
Last part of Article 37.
Therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of, and it shall be the duty of the state to apply these principles in making laws. Yes. If I will consider this very submission, observation.
In a way, what you are saying, you are not mandated to implement it. Then what is the use of making the law and laying a stress that this is fundamental in the governance of the country?
Yes.
Can there be a something fundamental in the governance of the country without implementation?
No, Honorable Bench.
So
However,
theref-
this is an issue, this is a separate issue which my co-counsel is meant to deal with in the third issue, that is. Yes. Honorable Bench, furthermore, the principles of uniformity versus commonality, which again is a submission in the third issue, was distinguished in the case of, if I may be given some time to finish my arguments. Yes. In the case as stated in John Valamotum versus Union of India. Furthermore, Honorable Bench, we need to consider, that is in the next sub-issue, we have just submitted the facts with regards to the procedural inaccuracy or unlawfulness of the state. Now, moving on to the substantial unlawfulness of the same, the counsels for the petitioners humbly submit that they have introduced a uniform legislation for divorce, maintenance, adoption, and so on. However, there cannot be a single best practice for procedures like, let's say, the prohibited degrees of relationship, the class 1 heirs when it comes to inheritance, because practices under various customs may be different, but they are not always discriminatory, Honorable Bench. Yes, Honorable Bench.
What is the role of Mahila Samaj Kalyan?
Mahila Samaj Kalyan
Just
is...
let me
Yes.
clarify that question and I'll leave that time for
Yes.
you. Is it a plain and simple succession dispute?
32 of the Constitution and Order 38, Rule 7 of the Supreme Court rules. The Supreme Court rules. This is why, because under mandamus, that
Region of interpretation, customs shape the identity of the tribes.
Isn't that
Customs aid in the interpretation of the constitution.
Interpretation, when the language of Article 30 is so clear, why there is a need of even looking at that act?
Indeed, Honorable Court, because our submissions is not based on Article 30, but rather Article 29 of the Constitution. So that is why, in order to satisfy the court, we have tried to establish that the Muslims enjoy a minority status within the territory of Himvarsha. If I may, yes.
Our Sikhs and Buddhist Jains, they are all minorities.
Indeed, Honorable Court, it depends on whether...
The provisions of Uniform Civil Code.
Apologies. Yes.
South India would be a linguistic minority in Chhattisgarh. And a Hindu would be a religious minority in Srinagar.
Yes.
So therefore there is no uniform. We have a polychromatic society.
Indeed.
Don't make it a black
Yes.
and white society.
Indeed, Honorable Court.
One question, one doubt I had is while the wife of that gentleman, whatever his name is, deceased, she is litigating in her own right. This second and third petitioners, the Tribal Wellbeing Association and Islamic Personal Law Board, this is a public interest litigation.
It has not been specified in the undisputed facts of the case. It has been only stated that there were writ petitions were filed. So whether the writ petitions were in the nature of PILs or not, that has not been specified.
My brother has already clarified when
Yes.
they are filing as an organization, no personal right has been violated.
Indeed, Honorable
So-
Court. Yes. If I may just satisfy the court on certain grounds in my issue. So firstly, because we have the two particular communities.
Interventions are intended to give you a feel of what happens in the court.
Absolutely.
See,
Much obliged.
Once a young parents came to me seeking advice as to whether the daughter should join the legal profession or join the corporate world where payments are high. In the legal world, you have to struggle from zero to, you don't even get money to buy a cup of tea.
Indeed.
Then when you are there, the corporate who's who come and sit in your antechamber for your appointment. That's a different matter when you are successful. So I told them, that Enter the Dragon Bruce Lee film, he breaks the bricks. So Bruce Lee tells that young fellow who wants to join him, bricks don't hit back. So in a court case, the judge is hitting you, the other side is hitting you. It's a real life battle, not a make-believe battle. So we occasionally hit you with relevant or irrelevant questions just to rattle you.
Indeed, Honorable Court, and in furtherance of what has fallen from
other
this.
words,
Yes.
not only you to defend yourself, but also pack up some aggressive punches as well in between.
Indeed, Honorable Court, what has fallen from the bench is that a real life problem, a practical problem, whether Christians, whether Jains, they form a part of the minorities, whereas certain communities have been included within the definition of Hindus under the Hindu Marriage Act, under the Hindu Code. So their identities are already under question, and suddenly the state comes in and implements a code that will be applicable to all communities, all religions, whatever be the definition of minorities. That there is difference of cultures, Honorable Court. We have cited references like the NALSA Protection and Enforcement of Tribal Rights Scheme, where they highlight that in the case of India, the tribes, they also don't form a homogeneous community. Be it the tribes of the Northeast, be it the tribes of a state known as Chhattisgarh, be it the tribes of the Deccan region, all these tribes are also inherently different in their customs. So suddenly a code comes in and it deals with issues like inheritance. So if I'm dealing with inheritance, automatically why I brought up Islamic customs. For instance, kafala is a custom in Islam that deals with the adoption practices. There is this system of inheritance in Islam that gives 12 shares of inheritance rights. So all these customs, they are in Islam and in other religions also. What has fallen from the bench, religion and customs are so closely intertwined that when you are saying a uniform policy shall be followed in the case of inheritance, automatically you are infringing the right to religion of certain communities, which in most cases, in many cases, might include the essential religious practices of those
Do you
communities.
think right of religion an absolute right?
Honorable Court, according to Article 25 of the Constitution, it is subject to public order, morality, and health. It is yes, there are other clauses as well.
The clause 2 also says something.
Yes, it says about the imposing of compulsory services for public purposes, and in imposing such service, the state shall not make any discrimination on grounds only of religion, race, caste, or class, or any of them. Yes, so the submission before this honorable bench is that suddenly there cannot be any custom or any personal law that is prevalent throughout the territory that has suddenly breached all public order, morality, health, all the parameters, all the reasonable restrictions that are present under Article 25. So,
Does bigamy or polygamy breach any evolutionary social norm?
if
Is there anything in the evolution of the species which says that one male shall have only one female or one female shall have only one male? Is there any evolutionary basis for that, or is it a creation of modern societies? Some sort of a ration card principle
indeed,
that
Honorable
everybody
Court,
should have. Otherwise, somebody who is not very wealthy or not very handsome, whatever that means,
yes,
will not be having a woman or a man as it is. The other fellow can have a harem. So therefore, law says that since sexual urge is as important as an appetite, it's also an appetite, human appetite. Therefore, equitable distribution of it's a ration card principle. Monogamy is a ration card principle. So the basis of monogamy is not that Prime Minister doesn't want men and women to have a good time. It is just that social peace is engendered by the wealth of the society, which includes the sexual wealth, to be distributed, to be enabled to be distributed equitably.
indeed, Honorable
That's the
Court.
basis.
That is
So law, if you understand law as a dictatorial command of a happiness prohibiting prime minister or the law minister, then you are less likely to be implementing the law. If you consider it as a socially equitable principle, you will have greater affinity to the law.
Indeed. if I may just
So it's
address.
an artificial contemporaneous value. 15,000 years ago, when we were living in the wilderness, there was no concept of marriage.
Indeed not.
There was no concept of
Yes.
Yeah.
Yes.
Thousand wives, right?
This is
was
where
no
the customs. Yeah. Yes. Yes, indeed. So this is where the customary practices comes in, and if I may just elucidate in one or two sentences, if we are referring
we'll
to,
give you 3 minutes,
yes,
which is the time consumed by us
yes.
by relevant and not so relevant interventions.
All right, Honorable Court. First, let me just address what has fallen from the bench. So, if I'm quoting Alport Gordon, he mentions, sociologist, when a norm is converted into custom through repetitive practices. If I'm quoting Austin, this custom gets a statutory recognition only when it is given the sanction, power of the sovereign backed by sanction. So this is where there is a discrimination between law and custom. Coming back to my submission. Differentiation. Yes, yes, yes. Yes. So my humble submission before this bench was, we are dealing with such customs that are a part of the legal system of Himvarsha. Why do I say so? Again, quoting Austin, a custom becomes binding when it gets the force of law. And there are several statutes that have given recognition to various customs. I would like to first refer to the Panchayats Extension to Scheduled Areas Act, page 48, volume 2, but I'll just reiterate. Section 3 mentions extension of part 9 of the Constitution. The provisions of part 9 of the Constitution relating to Panchayats are hereby extended to the scheduled areas, subject to such exceptions and modifications as are provided under section 4. What does section 4 say about the exceptions and administration of tribal areas through panchayats? It mentions, section 4a, a state legislation on the panchayats that may be made shall be in consonance with the customary law, social and religious practices and traditional management practices of community resources. Section 4d, every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources, and customary mode of dispute resolution.
Council, does it mean that if one law provides some condition for application of a law to the particular area,
Yes.
then those conditions ipso facto are to be complied with for every legislation?
Indeed not, Honorable Court.
That is what the point is.
The intention of the council is to establish that tribal customs that we are referring to are not merely performative customs. For instance, wearing the sindoor, vermilion, or for instance, the other things. We are referring to such customs that have gotten the status of customary rights that have been legally recognized.
No, Ms.
And
Counsel, are you building your argument on the issue of legislative competence or on the violation of rights?
I am premising this argument relating to customs on the basis of the issue that has been provided to us, issue 3, that is whether or not the Uniform Civil Code violates the customs of the people of Himvarsha.
As far as judicial review is concerned, law is
Yes.
very settled.
Yes.
Either it should be on the ground of competence or should be on the ground of violation of rights. Now, by
Yes.
bringing schedules 5 and 6
Yes.
and this act, what you are referring to, are you building the argument that Parliament is not competent to make the law on these subjects and thus this law should be declared unconstitutional, this code should be declared unconstitutional? Or are you building an argument that it's a validity of 29, 30 and 25 and therefore it should be? Or both?
Essentially, we have relied on both. We have tried to satisfy this honorable bench. My co-counsel has tried to satisfy that the procedural aspects in certain instances have been violative because of Article 13 and the definition of personal laws. But primarily,
Are you trying to convince this court on this point that a law can be declared unconstitutional on the violation of both? On the violation of both the grounds?
Honorable Court, in our prayer, we are very specific that the Uniform Civil Code there should be certain restrictions. I'll come to the prayer, but on the basis of violation of fundamental rights. That is the substantive portion of the law, the code that has already been enacted. We have prayed before this court. So if this court undertakes or acknowledges our submissions, then acknowledges. I apologize for the use of terms. If the Honorable Court is pleased to acknowledge our submissions, then, but we are specific.
Uniform Civil Code violates what of the Constitution?
Essentially, freedom of religion, freedom of culture, freedom of conscience, and also the right to equality. This portion would have been dealt with me in the final issue, that is whether or not exemptions should have been granted.
Counsel, you read Article 25 from where and deriving your right to religion, Clause 2, it says nothing in this article shall affect the operation of any existing law or prevent the state from making any law
Yes.
regulating or restricting any economic, financial, political, or other secular activity which may be associated with the religious practices. So it is clearly covered what the state has done. State has the power to make the law. Even if we consider this court consider it is a customary practice of a particular part of a population, even then the state has the power to make the law. How if there is a violation of Article 25 Clause 2?
Indeed, Honorable Court. It is a humble submission on behalf of the petitioners that in the instant matter it is undisputed that the right to life and personal liberty of various stakeholders have been violated. Now the state has the authority to infringe upon the right to life.
Don't go this side and that side dribbling the ball like a hockey ball. You come to Article 25 Clause 2, how it is violated?
Honorable Court, because the procedure established by law as followed by the state was
Where it is
not
written procedure established
just
by
fair
law?
and
Yeah?
reasonable. Honorable Court, Article 21, there has to be a harmonious
There is no
construction.
question here of a right to life. It is a question of religious practice. We confine your answer to that question.
Indeed, Honorable Court. So in that instance,
Minority.
yes, in that instance, there was no one unique practice that was violating any of the policies of the state, that all of a sudden state had to take action and abridge our right to religion and other aspects.
The last question from the court is,
Yes.
see, your thrust of your argument is that Uniform Civil Code has violated the customary right, which is part of their religion, right?
Yes, yes.
We are saying here 25 Clause 2 specifically authorizes the state to make a law. It may be existing law or it may be a fresh law through which you can regulate economic, political, financial or other activity which may be associated with the religious practices. Of course, custom is related to the religious practices.
Indeed, Honorable Court. So this very question of interpretation, since the Constitution is a living document, this question of conflict of personal laws and secular laws per se arose before the Honorable Supreme Court of India in 2024 itself. The case name is Muhammad Abdul Samad versus State of Telangana, where the Honorable Court has held, and if I may just read it out for the convenience of the bench, these expressions allow sufficient interpretive amplitude to reconcile the Muslim personal law with the secular law of maintenance, bearing in mind the constitutional objective of preserving and promoting the dignity of women. So the Honorable Court has held that wherever there is a conflict of the laws, we do not infringe upon the customs. For instance, in this matter, we do not say that the Muslim woman won't get maintenance under her personal laws, rather under both Section 125 CRPC and also the personal laws. So this is how the justice that was... yes, I just...
We will give you 90 seconds as we gave it.
Yes,
What do you
absolutely.
think is your best argument to present?
My best last submission will be with regards to whether or not exemptions should be provided. Now, Honorable Court, this Uniform Civil Code does not promote uniformity, but rather commonality. So, in order to bring in uniformity, certain classes that are distinct from the others, the state cannot promote equality among unequals. So, as to uphold the principle of equality in its true sense, exemptions must be provided to certain religious groups. And I base this argument on the basis of constitutional morality and transformative constitutionalism, because interpretation is the primary tool in the hands of the honorable judiciary.
It's meant by transformational constitutionalism and constitutional morality. How is it distinct from morality?
Indeed, Honorable Court. So, the basis of the argument is transformative constitutionalism means the constitution has to adapt with the changing needs of the society.
So every year there will be a constituent assembly continuously in session.
Indeed, not Honorable Court.
That every day's court, Supreme
Yes.
Court or High Court, and every day's lawyers and every law school will be a constituent assembly continuously in session.
That is why, if I may
You
just
transform the constitution.
if I may just
So
refer to
it'll be worse than a periodical, is it not? Worse than a daily newspaper. Daily newspaper only comes once a day.
yes.
So you can have a different constitution in the morning, different constitution in the evening. So it'll be deforestation exercise if you have to print so many constitutions. There will be ecological issues.
Yes, indeed, Honorable Court. That is why we have Article 368. We have the basic structure doctrine. We have a due process of law, a procedure established by law, where there are checks and balances. This is where the argument of constitutional morality also comes in, whereby we cannot judge a new legislation only on the basis of social customs or social morality, but rather within the ambit of all the fundamental rights and other rights that has been provided by the Constitution.
Is it by the text or your own assumption? That is the only reason. Should you believe that the only reason you did not draft the constitution was that you were born after Ambedkar? Had you been born then, you would have drafted a better constitution. Is that the way to read the constitution? Or take the constitutional text as invariant and then try to interpret it as the language permits? What is the role of the judiciary that you would like to propagate?
Indeed, Honorable
You
Court.
want the judiciary to be a constituent assembly in daily session, barring summer vacations?
Indeed not, Honorable Court. That is why we have the separation of powers in the state, which is a part of the basic structure doctrine. The Honorable Judiciary, what the Honorable Judiciary does is interpret the Constitution
Separation of power of what?
between the executive, legislative, and the
Where it
judiciary.
is mentioned legislative.
The legislature has been mentioned under
They are separate parts of the constitution.
yes, under the separate parts of the Constitution. And when we are talking about the Constituent Assembly, as far as the knowledge of this council is concerned, the Constitutional Assembly is different from the Parliament in today's date. Yes, because
Parliament is also a constituent body when it comes to amendment of the constitution.
yes, that is why what
A separate
document
majority is required, special majority is required, but the same body.
yes, what
So-
document we had in 1947 that has transformed.
And
that
the
has,
first constituent assembly became the parliament.
indeed, that is
It sat as a parliament.
yes,
Those are the historical evolutionary aspects of it.
yes.
But tell me, does the Uniform Civil Code also violate the basic structure of the Constitution inasmuch as it transgresses the governor's discretion to apply or disapply any law to a tribal area?
Honorable Court, with regards to
You have not dealt with that.
Yes. With regards to Schedule 5 of the Constitution, there is no binding precedent that whether or not Schedule 5 forms a part of the basic structure doctrine.
Precedent is what you make, is it not? If you persuade me well enough,
Yes.
you and I together make the president, the lawyer and the judge. President is not created just because some Brahma has created it. Each of us is a Brahma. We keep on creating precedents. That's what we are paid for. The question is, if
Yes.
Part 5 is a part of the Constitution, if Uniform Civil Code is a legislation which is made subsequent to the original Constitution,
Yes.
it has to answer the test of constitutionality
Indeed.
insofar as it derogates the constitutional prescription in Schedule 5 of giving the governor the discretion to apply or disapply laws to a tribal area.
Yes.
Does the Uniform Civil Code, which does not or removes that discretion of the governor, violate basic structure?
Honorable Court, as you mentioned, if I am persuasive enough, then the court may issue a ruling
That's a
in
matter you
this
should have
favor.
considered
Yes.
in greater depth.
Yes, whether or not Schedule 5 forms a part of the Constitution, but why we
No,
did
it is-
not
it's part of the
basic
Constitution, no
basic
doubt.
structure doctrine. Apologies, Honorable Court.
It's a
but-
basic structure because it is enacted by Ambedkar and not
Yes.
by his next generation. Everything which is part of the original constitution is basic structure.
Yes,
That cannot be
was-
struck down. Any
Yes.
amendment to the constitution or laws made pursuant to such amendatory provisions
Yes,
by the Grade 2 Constituent Assembly, which is the parliament sitting in constitutional amendment.
yes.
That is Grade 2 Constituent Assembly.
Okay,
Grade 1 is the 342 founding fathers.
okay.
So,
And founding mothers.
mothers, yes,
Yes,
true. 46 of them.
yes. Obliged. So if I may quickly move on to my prayer, because I think I have exhausted my time.
You are well past the time
Yes,
been
indeed.
allotted to. But that's fair enough. The Honorable President thought that you should get the time and therefore you have given. And thank you very much, Council.
I'm much
You have a
obliged.
long reply.
Indeed. So there is no need to go through the prayers, is it? Prayer. Okay. So we have prayed before this honorable court that this court may be pleased to issue a writ in the nature of mandamus against the concerned employer, ordering him to consider the application of the concerned petitioner number 1, that is Mackenzie, for compensation under the writ of certiorari and compassionate appointment posthumously awarded to Shemping. Secondly, may be pleased to declare that the Uniform Civil Code is unconstitutional for the lack of appropriate legislative power, as I just submitted.
That's the first question.
Yes, yes,
You copy it.
indeed. That is a humble submission on the Council's part. And for its enactment and subsequent violation of fundamental rights. Thirdly, may be pleased to declare that the Uniform Civil Code infringes the rights of tribals and other communities to preserve and practice their customs. Fourthly, may be pleased to declare that the enacted statute is in the nature of common civil code, for that, in order to ensure that the intended uniformity is achieved, appropriate exemptions to the tribal communities and other religious groups must be provided. Fourthly, for that, may be pleased to issue a writ in the nature of mandamus or any other appropriate writ, order or direction on the respondent state to repeal and or introduce appropriate amendments in the impugned statute. And finally, for that may be pleased to direct that the Uniform Civil Code be not recognized or given effect until necessary amendments are carried out and or the code is duly repealed. And for this act of kindness, the petitioner shall duty bound as ever. Pray. It was a pleasure arguing before this bench.
It is up to the discretion of the judges, but it cannot. Greetings to the bench. This is the counsel on behalf of the respondent in the matter of Mackenzie and others versus Democratic Republic of Himvarsha before the Supreme Court. The counsel seeks permission to collectively address the bench as a lordships and individually as a lordship.
Yeah, go ahead.
Much obliged, Your Lordship. Indeed, Your Lordship. Your Lordship, the counsel will be taking 24 minutes of the court's time and my co-counsel will be taking 18 minutes and 3 minutes shall be reserved for sir rebuttals. If Your Lordships are well versed with the facts of the case, the counsel seeks permission.
You should presume that, you have been observing that for this long.
Indeed, Your
Do you
Lordship.
think that we have not been sufficiently literate on that? begin on track.
Indeed, Your Lordship. Your Lordship, the Council will be dealing with the first and second issue related to exemptions and preservation of customs. Your Lordship, first issue states that whether the Uniform Civil Code should provide exemptions to tribal communities, and the same will be discussed, Your Lordships, in a threefold manner, stating firstly the historical marginalization of tribal communities, secondly the flexible approach of UCC, and thirdly the rational basis for distinguishing tribal from other communities. Your Lordships, the Uniform Civil Code is crucial for promoting equality, gender justice, and national unity by creating a uniform legal framework and standardizing personal matters across all the communities in Himvarsha. Your Lordships, historically, the religious personal laws have always led to discrimination, and the UCC aims to eliminate these biases by standardizing these laws. Firstly, Your Lordships, it is humbly submitted that before the Honorable Court that the UCC should provide limited exemptions to tribal communities, and such exemptions will not be discriminatory toward other communities because tribal communities occupy a distinct historical and cultural position that warrants special considerations. If Your Lordships may refer to para 11 of the Moot proposition as well, the Union Minister of Home Affairs indicates the government's consideration of amendments to the UCC to provide exemptions to tribal communities. Your Lordships, even the Constitution of Himvarsha recognizes the distinct status of tribal communities. Provisions like Article 244, 244A, 5th and 6th schedules provide special provisions for the administration of tribal areas. Your Lordships, therefore, it is necessary to preserve the identity while integrating them into a modern state. If Your Lordships may refer to the case compendium flag 29 as submitted, in the case of Samatha versus State of Andhra Pradesh, this case highlighted the plights of the tribal communities. Flag 29. Indeed, Your Lordship. Your Lordship, this case also held that it is the responsibility of the state to protect the land, resources, and culture of the tribal communities from exploitation. This is... no, it is Samatha versus State of Andhra Pradesh. Apologies, Your Lordship. Your Lordship, special provisions for disadvantaged groups are permissible to achieve substantial equality. Your Lordship, the tribal communities are in a more vulnerable position compared to other communities, necessitating special protection under the UCC. Providing limited exemptions would be consistent with the Constitution as well as the judicial principles, ensuring that the tribals can maintain their cultural practices while gradually aligning with the national laws. Even the ILO Convention 169 and the UN Declaration of the Rights of Indigenous People, they also protect the rights of tribal and indigenous communities. Secondly, Your Lordship, it is humbly submitted.
Community. I thought all tribals are indigenous.
Yeah, indeed, Your Lordship, all tribals are here in the present matter. The council is referring to the tribal communities only. Indeed, Your Lordship. Your Lordship, secondly, it is humbly submitted that the UCC should be implemented with a degree of flexibility to accommodate the diverse fabric of the diversity under the Constitution of Himvarsha. It is not rigid in nature, but also rather accommodates the unique needs of tribal. Your Lordship, for example, even the Constitution has been amended a lot of times, and here also in the present matter, even if the Union Minister is considering for the exemptions, it should be allowed because the ultimate aim of the government is welfare of the state. Hence, the limited exemptions to the tribal communities must be provided. Thirdly, Your Lordship, it is humbly submitted that there exists a rational basis for distinguishing tribal communities from other religious communities while providing exemptions. Your Lordships, tribal communities face distinct...
Yeah, Ms. Counsel, you are also justifying this on the ground of affirmative action.
Indeed, Your Lordship.
Now, affirmative action by its very nature is transitory. Today or tomorrow it has to be done away with because it is a sort of means to achieve an end. Are you also in that way saying that UCC is also transitory in nature?
Indeed, Your Lordship.
So you are saying that in future the legislature should repeal this UCC?
No, indeed not, Your Lordship. Your Lordship, the Council is contending that the exemptions which the Council are aiming to provide, these exemptions are provided for a reason. The exemptions are being provided to recognize the vulnerable communities. And because these communities are not on an equal pedestal, and the Council agrees to it. The government agrees that there are communities which are not on an equal pedestal.
Affirmative action, by its nature, is about uplifting that community.
Indeed, Your Lordship.
Here, when you are saying exemption is given, you are arguing for status quo. Where is the question of uplifting then? You are saying that let them continue to be marginalized.
Indeed not, Your Lordship. Your Lordship, in as the society evolves and it progresses, since the government also aims for welfare of the state or welfare of the nation, the communities are being provided with education. They are being uplifted from the poverty. But here today, in the present matter, since there is a distinction that exists with the tribal communities, they definitely lack certain education. They definitely suffer from extreme poverty and alienation.
That's why this very basis of drawing analogy from affirmative action is misplaced, isn't it?
Apologies, Your Lordship, the Council is not aware.
Okay. Because your fellow council can quickly Google it up. You were talking about the poverty of the tribal. Poverty as we understand, right? I mean, fair enough. Okay, go on.
Your Lordship, the affirmative action here is that currently the tribal communities are not on an equal pedestal. But in future, when they ultimately reach on an equal pedestal, these exemptions might be eliminated from the Uniform Civil Code. But since currently today they are not at the same position, hence there is a requirement of the exemptions.
Are you aiming to eliminate the distinctions that exist, cultural, economic, other distinctions that exist between the tribals and the plains people?
Your Lordship, the aim of government is definitely to uplift other matters.
To level all the tribal
Indeed.
areas and make it plain.
Indeed not,
Valley.
Your Lordship. Indeed not, Your Lordship. But the matters related to education, poverty, alienation of land, these are the matters which can ultimately be removed or curtailed in future. But here UCC only talks about the personal matters.
What gives the state the arrogance to believe that you are superior to them, and progress for a tribal means that they should also be able to travel in a Mercedes Benz, whatever it is. Can you smell rain?
Indeed not, Your
He
Lordship.
can. Okay? You can't live naked in the forest. No, the human species is the ugliest of all the species. You are unfit to survive unless you wear a coat, a jacket, hat, raincoat, or something like that. A bear, a dog, a caterpillar, a mosquito is better adapted to living in nature. And therefore, this assumption, arrogance of superiority of the human species itself is a delusional concept. Unless you are punch drunk, you don't believe that humans are superior to other species. Among the humans also, the plains people believe they are superior to the tribals. Is it not?
Indeed, Your
So
Lordship.
compared to the tribals, all of us were tribals at one time. We all had our own witch doctors. We evolved from there to the modern witch doctors, giving them different names, constitutional and otherwise. When you want to create a uniform civil code, and you want the tribals also to go to a Pizza Hut or something like that, some arrogance is required for the plains people. So is a uniform civil code enactment a policy of arrogance?
Indeed not, Your Lordship.
Why do you want to make everything equal? You are not equal. The people, a cabinet secretary, a chief secretary, a prime minister, a minister, a high court judge, they are not common people. They sit on a pedestal, as you have seen in front of you. We are not
Indeed, Your
equal to.
Lordship.
We maintain our own delusions of superiority. So why should you make the tribal people are anywhere above you on the hills?
Your Lordship, currently the UCC does aim to unify the personal law, but it also recognizes the differences which remain within the
Where are the
communities.
recognition? It's your case as a state
Indeed,
that
Your
you are introducing an amendment. Why the tearing hurry to implement the UCC in its crude, unrefined form
Indeed,
before
Your
an
Lordship.
amendment which you yourself recognize will make it constitutionally valid?
Indeed, Your Lordship. Your Lordship, firstly.
Are you trying to gain political brownie points
Indeed, not Your Lordship.
without a constitutional purpose?
Your Lordship, firstly stating that the features of UCC which have been provided under para 5 of the Moot proposition, it also recognizes the customary practices. The UCC initially has also recognized the customary practices, and now when we see that there are certain conflicts arising as well, the UCC is also flexible in its approach to inculcate those conflicts and resolve those conflicts which has been arising.
So, on your interpretation of the UCC to the facts of the present case, are you saying that the administrative action of granting compensation and compensatory employment to the brother's widow instead of the common law living together first wife, so called, is administratively wrong?
Your Lordship,
What is your case?
Your Lordship, our case is
If
that
that is the case, the other points of the petitioners are not relevant. We need not consider constitutional questions.
indeed, Your
When you
Lordship.
can do with a broomstick, you don't need a nuclear device.
Your Lordship, our case here under the compensation and compassionate appointment is that the second wife should receive the compensation, but in my further arguments, my co-counsel will be dealing with this specific issue. But here also, the state here is aiming that since this issue is an under UCC issue, since the UCC has been implemented, and hence my co-counsel will be substantiating how the second wife is the legitimate wife and how the first wife is not the legitimate wife, and hence she will be further substantiating.
The expression wife. If you use the expression wife, can a wife be a legitimate wife and an illegitimate wife?
Apologies.
In fact, I was taking very serious exception to the fact that someone you become an illegitimate son or daughter. It's not their fault actually.
Apologies, Your Lordship.
Isn't it? Huh?
The counsel shouldn't
Let's
have used
be
the
very
term.
careful about the expressions we use.
Indeed, Your Lordship. Indeed, Your Lordship.
Particularly a society like India, we had no problem against polygamy. We had no problems about polyandry. Right? You have a lot of instances from epics on that. Actually.
Indeed, Your Lordship. Apologies for the same. Your Lordship, apologies. Indeed, Your Lordship.
One man, one woman.
Your Lordship, but these practices have been discriminatory in nature. That is why the UCC aims to.
Not discriminatory, they're just different. Just because you and I look different, it's not that you are superior or I am superior.
Indeed,
we
Your
are
Lordship.
differently manufactured
Indeed, Your Lordship.
or evolved.
Indeed,
That's
Your
all it
Lordship.
means. So don't look down. This idea of the state looking down on some aspect of society as some unclean.
Indeed, Your Lordship. That is
we
why.
did those, those Harijans
Indeed, Your Lordship.
because they were doing unclean jobs. They were only cleaning your filth. Is it not?
Indeed, Your
So
Lordship.
therefore, otherwise you would have been in that filth. So they are not unclean. You generated the whatever. If it is unclean, you generated it, and they were helping you clean it. So that's how we evolved. So therefore, don't look down.
Indeed, Your Lordship. That is why the
Particularly-
UCC.
I'm saying that to you because you represent the state.
Indeed, Your Lordship. But that is why the state under UCC is also recognizing for exemption.
Why are you bringing the amendment?
Your Lordship.
To make it better.
Indeed, Your Lordship.
Therefore, it is imperfect today.
Your Lordship, we cannot say that the UCC is imperfect today.
Then you want to make it more perfect.
Your Lordship, even the constitution was implemented and later the amendments have been made, but that does not state that the constitution was not in need of the time. Here, here there have been cases, the discriminatory practices have increased a lot in number. The triple talaq case, the Shah Bano, the Shaira Bano judgments. There have been the increase in discriminatory practices within the personal laws. Hence, there is a dire need of UCC currently today in the present matter. That is why, and also the UCC before the implementation.
Relatively, people belonging to the Islamic faith are part of the national mainstream in comparison with the tribal communities which have been remotely located and there is not so much of integration because they are not really part of the main society. So is it appropriate for you to compare the Islamic minority with the tribal minority and treat them as equals in the present case?
Indeed not, Your Lordship. Your Lordship, here by providing tribal communities the exemptions, since also religion is a broader faith, the tribal communities also inculcate certain religion, and by providing exemptions to the tribal communities, we also provide the exemptions to the vulnerable religious communities as well. Much obliged, Your Lordship. Your Lordship, the second issue states that whether the Uniform Civil Code infringes on the rights of tribal and other communities to preserve and practice their customs, and the same will be proved to Your Lordships in a threefold manner, stating that it preserves the essential customs, secondly, it eliminates the obsolete practices, and thirdly, it enhances legal protection and clarity. Firstly, Your Lordship, it is humbly submitted before the Honorable Court that UCC is fully in harmony with the Constitution of Bhimvarsha and preserves the essential customs in accordance to the constitutional provisions. It aligns with Article 29 of the Constitution, which protects the interests of minority. It also, if Your Lordships may refer to para 5 of the Moot proposition, it also, the features of the Uniform Civil Code allows for marriages to be solemnized according to the customary marriage practices which includes the nikah for Muslim and saptapadi for Hindus, provided that it may be proven to be a customary practice. Your Lordship, this...
I'll stop you here for a moment.
Indeed, Your Lordship.
Look at para 5.
Indeed, Your Lordship.
For 2.
Point.
Marriage is to take place as per the prevailing customs.
Indeed, Your Lordship.
Does it rule out marriages under the Special Marriage Act, where there is no custom that need to be followed?
Your Lordship, the Special Marriage Act is a situation where the two different communities, the tribal communities.
Very simple. I mean, it can belong to one person can, see, for example,
Indeed, Your Lordship.
can marry.
Saptapadi and
Indeed, Your Lordship.
Marriage. It's enough that if one of the spouses are Christian,
Indeed, Your Lordship.
only in respect of an Islamic marriage, both have to be belonging to the members of the Islamic faith.
Indeed, Your Lordship.
My question is, can you have a marriage without a ceremony? Like the way Mackenzie had with her husband.
Your Lordship, it depends on solely the customs
I
which...
am asking with reference to the facts of the present case.
yes.
That's all.
Is it not a customary practice? Example, nikah for Muslims, saptapadi for Hindus, provided it can be proved to be customary practice.
Indeed, Your Lordship.
So the question is it comprehensive? That is only nikah and saptapadi, or other customary practices are also accommodated in 5.2.
Your Lordship, firstly, it has to be...
So marriage by elopement, for instance.
Or have you heard of the self-respect marriages of Tamil Nadu? Have you heard of them?
Yes.
Apologies, Your Lordship.
A person declares before a group of people, I take him to be my
Custom
wife.
cannot be proved.
I take him to be my husband. The lady says, I take him to be my husband. And the man says, I take her as my wife. That's all. Marriage is performed.
Indeed, Your Lordship, the term custom here is interpreted as the way they want to marry. It does not... It is not...
I think you have done little more research because I don't think you need to have a ceremony for one to have a match. Thank you very much.
Indeed, Your Lordship. Your Lordship, this also highlights the legislature's intent to preserve the essential customs as well as religious practices, thereby ensuring the enactment of Uniform Civil Code does not result in erasure of community-specific rituals. Secondly, Your Lordship, it is humbly submitted that the UCC eliminates the obsolete practices which are discriminatory in nature and adapts to the evolving societal norms and the practices which are in the progressive society. Your Lordship, if Your Lordships may...
Excuse me. Who will decide in terms of scheduled tribes that these practices are obsolete?
Your Lordship,
Who has given you that right to decide? You are not a tribal. How do you decide that the practices are obsolete? Which body will decide that the practices practiced by tribals are obsolete?
Your Lordship,
Where is the forum?
indeed, Your Lordship. Your Lordship, firstly, the practices which are violative of the fundamental rights must be claimed as discriminatory in nature because the essentially so Constitution is the supreme law of the land. But also, the government can constitute
As far
forums.
as tribals are concerned, even in the present case, that elopement is not in conformity with the Constitution. You will find many practices which are not in conformity with the Constitution.
Indeed, Your Lordship.
Yeah, you have to treat them or give a special status.
Indeed, Your Lordship. Your Lordship, but here in the present matter as well, the government can definitely make forums in order to decide what the discriminatory practices are.
I have a question. When you say Uniform Civil Code, what do you mean by that?
Your Lordship, the council means that we will standardize.
What do you want to achieve?
Your Lordship, the different customs, we want to standardize the laws which are related to marriage, divorce.
Are you for a change or are you for a reform?
Your Lordship,
Are you for a change for the change's sake because the government is interested? Or are you for a reform in personal laws?
Your Lordship, we are for a reform in personal
Who
laws.
gave you that power to reform in personal laws? They have their own status.
Your Lordship, but any practice which will go against the fundamental rights of the Constitution, they...
What are the fundamental values of the Constitution? I don't understand. What are they?
Your Lordship,
That is the marriage by consensual marriage, two persons living together. That's a custom of the tribals.
Indeed, Your Lordship.
You consider that abhorrent? By what standards?
Your Lordship,
Your grandmother would consider your eating pizza, not cooked at home by your mother, to be an extremely regressive, worse than tribal behavior, according to your grandmother. So, is she right or you are right?
Your Lordship, currently the UCC is talking about the personal matters specifically, and Article 13 as well states that the laws inconsistent with the fundamental rights are to be void. Hence, we are only talking, even under UCC, we are allowing for the customary practices. We are recognizing these customary practices. We are only eliminating the discriminatory practices.
What do you mean customary practice? Discriminatory against what? Against tribals inter se or with you?
Discriminatory against the Constitution of India, Your Lordship.
Constitution of India.
Of Himvarsha.
No, I understand.
I just want to ask you a question. Can you assert constitutional rights against your grandmother? Can you?
Indeed not, Your Lordship.
You did not, right? Okay. Now, a good answer, I take it. One more quick question. As an adult human, do you recognize the rights of people to keep their marriages secret?
Indeed, Your Lordship.
Then Mackenzie's marriage is not a bad marriage.
Your Lordship, when we, Your Lordship, firstly, the UCC does recognize the customary practices. And Your Lordship, the Council would like to reiterate that apologies for stating that against only the discriminatory practices against the Constitution, but also towards the society. The society, if we are a progressive nation, the society is evolving. There is a desirability of the Uniform Civil Code, and the courts cannot always intervene when there is a discriminatory practices which arise within the personal customs.
Council, long back,
Privy Council said, if there is a clear proof of custom, it will outweigh the written text of law. That is the force given to the custom. So you critically look at custom when those conditions of valid custom are not satisfied, right? So custom per se is not bad.
Last question, counsel. This Uniform Civil Code legislation that you have brought about, is it prospective in operation or retrospective in
It
operation?
is prospective in operation.
If it is prospective in operation, how does it invalidate the customary living together which amounts to marriage of those guys?
Mackenzie and Shemping. Indeed, Your Lordship. Your Lordship, here Mackenzie and Shemping lived in a secluded region which where nobody knew about their marriage. Examples can arise if two people do not even marry, and for example, if Shemping here in the present matter, if they were not married, Shemping died. Anyone can come up with a child and come to claim that this person married and I was married to this person.
That's so easily possible here. We live in days of, genetic fingerprinting and DNA analysis. That's not the case here.
Indeed,
So
Your
are you saying that you have rejected her claim for compassionate appointment and compensation
Indeed, Your Lordship.
because of lack of proof of marriage or because of UCC?
Your Lordship, it is
If
because
it is lack of proof of marriage, UCC, challenge to UCC doesn't arise at all.
Indeed, Your Lordship. Your
Is it
Lordship,
not?
It is,
There is no marriage, so where is the question of her being a claimant?
Your Lordship, there is a lack of proof of marriage that, and it is also that the second marriage is valid, and my co-counsel will be further substantiating on this. The issue currently here is that how UCC is preserving those customs, and the UCC is preserving the marriage customs and even the other personal matters of.
You have to conclude as we gave it to others.
Indeed.
We'll give you 90 seconds.
Indeed, Your
Okay.
Lordship. Indeed, Your
Present
Lordship.
your best argument.
Indeed, Your Lordship. Your Lordship, here UCC also recognizes the customary dispute resolutions as well. Bringing UCC does not mean that we will not, since we are also inculcating the tribal communities, we recognize the Panchayat Extension to Scheduled Areas Act, which provides for administration of tribal areas, granting them the autonomy to preserve their customs. Hence, by incorporating both customary practices as well as the statutory provisions, the UCC preserves the cultural heritage of tribal as well as other communities. Your Lordship, to conclude, the Council would say that the UCC is aiming to provide exemptions to the tribal communities, and it is also not violative of the fundamental rights because it does recognize the customary and religious practices. Hence, it upholds its validity.
Thank you very much, Counsel.
Much
I think,
obliged, Your Lordships.
Your other counsel will take the.
It was an honor to present before this court. Much obliged, Your Lordship.
If your lordships are satisfied with the arguments of the co-counsel, the council seeks
We
permission.
don't give any undertaking or an admission of our state of mind. Do judges do that?
The council seeks permission to proceed further.
You have a right. Exercise the right.
Much,
What if you are entitled for? You don't have to ask somebody's permission.
much obliged, your lordship.
I always believe young lawyers must demand justice.
Indeed, your
Demand it
lordship.
politely.
Indeed, your lordship.
Okay, demand. Don't beg.
Indeed, your lordship. Lordship, the issue before this honorable court is whether the Uniform Civil Code is constitutionally valid and aligns with the fundamental rights of the Constitution of Himbasha. The same shall be dealt by the council in a fourfold manner. Firstly, that UCC aligns with the right to equality, whereas personal laws are violative of the same. Secondly, that right to life and personal liberty is protected under UCC. Thirdly, it allows to practice and profess religion
it allows to practice and profess religion under Article 25, and fourthly, that UCC aligns with Article 44 of the Constitution. Lordship, it is most humbly submitted before the Honorable Court that UCC aligns with Article 14 and 15 of the Constitution of Himvarsha because UCC reflects intelligible differentia by incorporating limited exemptions for tribal communities to ensure that these customs are respected while pursuing uniformity in civil laws. UCC creates a classification based on specific needs of the society and specific needs of the custom of different communities, Your Lordship. These communities have unique cultural practices and face distinct socio-economic struggles and challenges which set them apart from other religious groups. Hence, UCC's goals to promote equality and national integration by unifying personal law is justified. Your Lordship, the reasonable nexus between the classification and UCC's objective is very clear. The inclusion of exception for certain communities strikes a balance between uniformity and diversity, ensuring legal fairness without irrational distinction. Lordship, personal laws while personal laws create arbitrary classification based on religion, gender, and community, violating the right to equality guaranteed under Article 14 of the Constitution. Lordship, in the case of Shaira Banu versus
Ms.
Union-
Consul, the framers were well aware of the fact that there is a practice or there is a kind of uncodified law in the form of personal law prevalent in this country
Indeed, Your Lordship.
prior to 1950. If we consider that it was well prevalent and it was well aware to the framers, they should have explicitly included in the definition of Article 13. They decided not to include, meaning thereby the intent of the framers were not to bring personal laws within the ambit of Part 3. So why we should not give a further, reading to the intent and not to admit your argument on this count?
Your Lordship, there have been cases where it has been held
Want
that
uniformity, why didn't you amend the Hindu Marriage Act and the Special Marriage Act to permit elopement as the only form of legitimate marriage? That would be uniform, is it not?
Your Lordship, if
Now,
different
if tribals are your evolutionary seniors and you came later and settled down in the plains, riparian settlements, which is well documented, then you are trying to say that somebody who eats pizza is superior to somebody who eats khichdi, your grandmother. You are tribals. You are plains people. You eat pizzas and burgers. Your grandmother was a tribal. She eats khichdi, dal khichdi. You think you are superior to her. So instead of that, ban pizza, make khichdi the only legitimate food. So similarly, ban all the, these ecologically deleterious and harmful and retrograde practices like, 40 course dinner in a convention hall in Naya Raipur, then a big fire where you create so much of smoke and all that. Instead, just two guys go ahead and live together, elopement, and that would be a very cultured, civilized form of marriage, isn't it?
indeed not, Your Lordship. In
That
this present
would
matter,
be a very refined uniform civil code.
Your Lordship, in the present matter, the government is not trying to show any superiority. We are instead ensuring that not only pizzas are allowed, eating pizzas are allowed, instead the people who need khichdi to be eaten, they are provided with khichdi as well. So that is what the council contends, that the tribal communities which are in need of...
Elopement is a valid form of marriage.
Your Lordship, elopement, if it is known to the public,
Who is public?
you'll-
Is just a ritual where a lot of unwanted people come and hog on food which they can't digest. Okay. It is not that if the couple, fight, none of these thousands of guests who come and hog all that food for free, none of them come and mediate the disputes between them. They go away. That evening over, they go to the next free meal. Okay. This is what happens in modern ostentatious marriages of the special international airport variety or less than that. So that is not a cultural evolution. Now, marriage is the consummation of marriage is always a private affair. Puttaswamy protects that.
Indeed, Your Lordship.
English kings, they had to consummate the marriage. English royalty, they had to consummate the marriage in the presence of 71 office holders, including the archbishop or deacon. The nuptials had to take place in the public domain. We have moved from that era. It's a private, they protect the right of privacy in the marital bed. So that they were not married, does it require a gazette notification?
Your Lordship, indeed, marriage is a private
Or living
affair.
in seclusion, that is living privately, is it prohibited under the constitution, amended or unamended, pre-uniform, pre-UCC or post-UCC?
Actually, I should point out an observation of Bernard Shaw here. He said, a marriage is a costly public confession of a strictly private affair. So this is a question I asked to the other side also. Is it right for people to have a secret marriage? That's all about it actually.
Indeed, Your Lordship.
Because you say that the earlier marriage was secret.
It's not secret. A consciously publicized marriage, is it a necessary condition for the validity?
Your Lordship, indeed, marriage is a private affair. But when the question arises regarding providing compensation and compassionate appointment,
Who
it
is-
becomes a matter of public.
Who is questioning that the compassionate appointment officer?
Your Lordship,
Has any marriage taken place, even a modern plains marriage, has it taken place before the compassionate appointment officer?
indeed not, Your
No,
Lordship. The
it
council
happens
contends-
somewhere else. Some 500 fellows come and eat free food and go away. Compassionate appointment officer recognizes the marriage because either it is registered or some priest is there, or they walk, the only morning walk or afternoon walk they do is around the fire 7 times, and they are fasting that day. This is the ritual, is it, of marriage, of Hindu marriage at least. Similarly, of a Muslim marriage, there is the nikah ceremony. So, is that a condition precedent to a valid marriage? Both of them are agreed that they were married. Nobody else says, she eloped with me. Is it anybody's case in your facts that the claimant, does anybody else, any other male claim that the claimant has eloped with him? That's not the
Indeed
case.
not, Your Lordship.
You are a marriage officer, you are a compassionate appointment officer. No marriage has taken place before you in your service.
Indeed, Your Lordship.
So what is your, what are you fighting?
Your Lordship, in the present matter, indeed, the public declaration of marriage is not essentially required, but when the question, as in the case of Mackenzie, when the question of compensation, compassionate appointment arises, a declaration needs to be present so that the public, the authority which is assigning, which is delegating, giving the compensation should know that there was a marriage that took place. Just by assertion of fact that the people married cannot provide them with the compensation. Your
Has the brother's widow disputed the living together of the claimant and the deceased? She doesn't. She merely says, my marriage has taken place under that whatever, their another customary right.
Your Lordship, but another problem that arises with non-disclosure of that marriage by elopement is that even if when the question of compassionate appointment arises, the government needs to know that the person was already married to a particular lady, so as to being able to provide the compensation to that person, and the other marriages don't get recognized.
See, let me take out the case of Mackenzie.
Indeed.
Okay, what about the kid? The kid is born, 3-year-old. You are denying Mackenzie the right to inheritance or appointment because she is guilty of a conduct which you consider that, secret, other people have no possibility of knowing it, I grant it. What about the rights of the child? The child is a legal heir or not according to you?
Your Lordship, since
Answer the question. Is the
He's
child
not.
a legal heir or not?
he's
alone
not
issue,
the
huh?
legal heir, he's not the legal heir of
Will
shaping,
they
Your
not
Lordship.
be entitled for anything under the existing law?
Your Lordship, in the present matter, the government
have
can.
you considered the rights of the Child Convention, International Law Convention?
Uh,
First right of a child is right against bastardy.
Indeed, Your Lordship.
So therefore, I'm just trying to, all right, here you say that this lady had kept her marriage secret, so there is no way the other person would have known it, and they married. She is treated as a legal heir. Now what about the kid?
Your Lordship, indeed, in the present matter, for the welfare of the kid, the government will provide assistance and aid which is required.
No, this is
Your Lordship,
government should not provide assistance because the council feels that way actually. In fact, government advocates do not have that kind of right or authority in our country actually.
Your
You know,
Lordship, it is humble.
Government will give if they are entitled for. Government will not give and should not give if they are not entitled for.
Indeed, Your Lordship, it is humbly submitted that for the right of the child, here in this particular matter, Sera Sema is rightly
What is
entitled
the
for.
position of an illegitimate child under the present Hindu Succession Act?
The child will not be given the property.
Deemed to be legitimate. The child is deemed to be legitimate.
Yes, rights
Apologies,
of
Your
the,
Honor.
see, this is where the rights of the child convention come. The problem with both the teams as I see it, you have been fixated only with the marriage, not inheritance and social status. No, Uniform Civil Code considers those aspects as well actually. That's something I want you to be aware of. Are you aware of that North Sentinel Islands? No,
Not your.
you haven't. Okay. Parent.
Your Lordship, additionally, in this present matter, Sera Sema's. Indeed, Your Lordship. Your Lordship, in the present matter, Sera Sema's marriage with Shemping is legitimate, is valid in the eye of law because they performed marriage by following a custom. And the second essential feature of UCC allows for marriage to be conducted by following their customary practices. And they married by levirate marriage, and this is recognized under UCC. Further, their marriage was registered under UCC. And Your Lordship, the fact that the council contends for the knowledge about the marriage between Mackenzie and Shemping to be known, that had it been known to the government, the second marriage would not have been registered. Since that was not known to anybody, that marriage did not take place in the eye of law, and the second marriage was registered. That
Let me ask you one question. One more question. Under the law, there is an obligation to register the marriage within a week's time.
indeed, Your Lordship.
Is it a week's time an unreasonably short time for the registration of wedding?
Indeed not, Your Lordship. The council would humbly defer to the fact it is not unreasonable time. The requirement, the registration of marriage does not require a very large amount of time, since giving a large amount of time will lead to distortion of various facts and various.
See, as a government, I will appreciate, make all marriages have to be done in accordance with these ceremonies. This is one aspect. The other aspect is, hey, you don't have to have any ceremonies. Have it registered before the marriage officer straight away. You know, it's one of the two should be enough, right? Why do you have to have a ceremony as well as the registration? And that too within a specific time of 7 days.
Your Lordship, the purpose of providing the purpose of providing to follow the customary practice is to protect those people who practice those customary practices.
No, who make money out of it. You make the
Indeed not, Your
tribal
Lordship.
priest. You protect the tribal priest, that's all.
The purpose of providing
You only
the
protect
scope.
the priest.
Indeed
not
not.
the people.
Your Lordship,
Not
not
the
every
community.
custom requires the function of priest there. Not every custom involves priest. It is only the only purpose of providing the customary laws, customary practices to be followed in marriage is to promote and to restore the position of those tribal communities back into the society, Your Lordship.
So an elopement in the presence or in the company of the marriage officer would be legitimate.
Apologies, Your Lordship.
Elopement in the company of or in the presence of the marriage officer.
Indeed, Your Lordship, it will be valid, because then there is a scope that somebody has the knowledge about their marriage, somebody is the witness or has the knowledge, and that can be recognized that a marriage has already taken place. There is a knowledge
So
to few.
therefore, your UCC, that curious UCC that you have brought about, recognizes that levirate marriages,
Indeed, Your Lordship.
does not recognize marriage by elopement.
Your Lordship, it does not recognize when the question.
Is it not clearly violative of 14? One
Indeed,
custom, you are not disputing the existence of that other custom.
Your
You are
Lordship,
saying I won't recognize it because the arrogance of the plainsman.
Your Lordship, a customary practice is not recognized when it goes against the fundamental rights or the public order. In this
Fundamental
particular-
rights, whose right?
The right of Sera Sema
what
to
is your
claim-
right living in around Pizza Hut to decide how the guy in the tribe lives?
Or otherwise, you must say how UCC preserve the essential customs in accordance with the constitutional provision.
Your Lordship, it
There is no
provides-
fundamental right of one citizen. You have parted your hair in a particular way. Is that the fundamental right or the fundamental way to part hair for a woman?
Indeed not, but
Is her parting, your colleague's parting of hair unconstitutional?
indeed not, Your Lordship. Everybody has the choice to do.
In fact, majority, two of them part their way in the same way. Therefore, your parting of the hair is unconstitutional to the majority.
Indeed not, Your Lordship.
So, what are
Everybody
you
has
talking
the
about?
Your Lordship, the fact that UCC provides exemptions to few of the communities to the
It's
tribal.
not exemption. It is recognition of.
UCC in itself
Asymmetry.
recognizes certain customary practices, Your Lordship.
See, that arrogance of the word exemptions is that you are the giver.
Giver.
You are not the giver.
You call it exemption.
You see,
Someone will describe it as discriminatory.
you know, the essence of democracy is the wielding of public authority is not a power. It is a responsibility.
Apologies.
Unless you start believing that the finance minister, the prime minister, the high court judge and supreme court judges underwear thread comes when a beggar buys a soap once in 6 months to wash his leprous body, you will not be a democracy. Public officers deliver responsibility. Nobody exercises power. Power resides only in the citizen of India. The highest political office in a democracy is that of the citizen. All other officers are servants. They are called public servants. High Court judge is a public servant. Prime Minister is a public servant. Of course, they behave like servants just during the time of elections. But after that, they become bosses. Okay?
Indeed,
And
Your
you,
Lordship.
the lawyers, you corrupt the judges when you say your lordship.
Apologies for
We are not lording over you. You pay our salary. You know, the height of democracy is recognized, is achieved when the person being convicted of capital offense of murder is simultaneously writing the confidential record of the district judge who is sentencing him to death. He says, I appointed this guy as the high court judge. He's a decent guy, competent guy. He appointed the district judge by due diligence. This district judge is a fair guy. He appreciated the evidence well. He understood the law well. And he has applied the law made by me through my 542 servants called members of parliament, the Indian Penal Code or Siksha Samhita or whatever it is. And according to the law made by me, according to the evidence properly appreciated by this guy whom I am paying salary, he has convicted me. That is democracy. So that arrogance that, you know, I have made the law, who the hell are you to make the law? If I boot you out of office after 5 years, then again you are in front of the ration officer asking for a red ration card.
Apologies for the same, Your Lordship.
Anyway, Counsel, we appreciate very much your spirited participation.
Good.
And the court officer had been reminding us repeatedly the time is over. I mean, she has been doing a job right. We appreciate that.
You prove a truism that I have experienced for 45 years, that government lawyers are always at a disadvantage.
They are not supposed to speak. That's what I used to mention.
You-
Anyway,
you normally
government
represent a-
lawyers speak less actually.
Usually indefensible client.
Anyway, counsel.
Good.
But
Good job.
I mean, as is the norm, we will give you 90 seconds for you to put forward your best argument. No lordship, no permission, nothing. Straight away. Shoot.
Indeed, Your Lordship. So, Your Lordship, UCC is not in violation of fundamental rights since it aligns with Article 14 and 15 of the Constitution. It has been brought by following the due procedure of law as already stated. It has followed all the due procedure in the Parliament, and hence it aligns with Article 21 of the Constitution as well. And Article 44 also provides the state with the power to bring a uniform civil code in order to harmonize the personal laws governing marriage, divorce, and other personal matters. Additionally, it also aligns with Article 25 of the Constitution because UCC governs the matter which are secular in nature. In various cases, it has been held that the matters like marriage, succession, all these are of secular character and they are not provided protection under Article 25 and 26 of the Constitution. And secondly, in the question of compensation and compassionate appointment to McKinsey, it should only be provided to Sera Sema, since the marriage that took place between Sera Sema and Shempeng was by following the guidelines of UCC customary.
Now I wonder, I'm sorry, whether he was a lawyer for government or the lawyer for terrorism.
The lawyer for government, Your Lordship, since
Light energy, fair enough. Thank you, counsel. I think you have done your job, fair enough.
the counts.
We don't have to tell what prayer you want. Avoid
But-
that. It's for the. It's customary for Moot court participants to do it, but you don't have to, isn't it? Prayer is always something in between what they are wanting and what you are willing to give. Thank you very much for your participation.
Much obliged, Your Lordship.
Thank
It was
you.
an honor arguing before
Thank
Your
you,
Honor.
both sides. The judgment is reserved.
That's it. But as per law, they are entitled for a reply. But rebuttal will have to be necessarily restricted to those their argument. If you are going to argue any new point, we will not take it very kindly. Yeah. Not more than 90 seconds.
Indeed, Honorable Court. So the rebuttal is restricted to one very fundamental question, that is, what is the nature of UCC and what is the state granting to us? Whether they are recognizing customs, whether they are stating that all customs are discriminatory, whether they are stating that tribal customs are only valid customs, whether they are stating whatnot. We are not certain about the true nature of UCC. That is why so much of confusion. Number one. Number two is that the Home Minister suddenly comes in, he gives a statement, and then again riots all over the country, that spread up. So in this light, we can say that UCC is a bad law because of the confusion it is creating, and the court has the discretion to declare it unconstitutional, firstly. And secondly, with regards to the issue that the two of them had regarding the illegitimacy, as we have already pleaded before this honorable court, that since Mackenzie had a child with Shempeng, therefore she is more entitled to the compassionate appointment and the compensation of 50 lakhs that was awarded by the state. That will be all.
Thank you very much.
Can law be declared unconstitutional on the ground that it is confusing?
On the ground that is arbitrary, honorable
Not
court.
on the ground of confusing.
No, it is
you stated-
arbitrary and disproportionate.
because you said it is creating confusion, that's why it should be.
Unfortunately, again is an incorrect word. Never mind.
Much obliged, honorable court.
Now your concluded arguments.
Yes.
One passing comment. Sir, rebuttal bhi hai. Okay. the English of the lawyers, we are talking
Yes.
about English because we are now doing it in English. It could be
Yes.
Hindi, it could be any language. As long as whatever language you employ, the language, we'll talk about English as an illustration of the contemporaneous language we use in courts. The language, the English of the lawyer should be much superior to the English of any English professor.
Indeed.
The reason is the English need not be lyrical, it need not be poetic, but it should be precise. The lawyer's English should have a mathematical precision, because what happens in the nature of democracies is that either the bureaucrat or some minister has a pinky idea that this policy is required. So it drafts a string of English alphabets, which is called legislation. That legislation gets passed in the legislature. The multiple number of legislators vote for it for unknown reasons. There is one English case where it was stated that one of the members of the House of Commons voted because he had a prostate problem. So he had to urgently go to the bathroom. So he just put his vote and rushed to the bathroom because otherwise he would soil himself. So he didn't vote because he liked the policy or disliked the policy. He had his personal physical reasons for voting to get out of that room, hall. So when you interpret a statute, you analyze the words.
Yes.
You don't psychoanalyze the legislators, right? So these 540 people have 540 different reasons for voting for the legislation. They employ language which is called English.
Yes.
Like all languages, it is plurisignative. English language is chronically plurisignative. Each word can mean 1,000 meanings. A rose can mean a different thing for a widow who is putting the rose on her husband's grave, to a girl who is meeting her boyfriend who is giving her a rose. The rose is identical.
Yes.
The flavor, the aroma is different for both. You impregnate it with your impressions. So this imperfect language, imperfectly understood by multiple number of persons, is made the policy. That is interpreted again by two sets of lawyers who have their own understanding of English language and independent grammar and syntax of their own. Every person is an independent grammarian. Okay. This is presented to a judge who or she has her own independent understanding of the language and grammar. And it is dictated to a stenographer who often overrules the judge in typing it. The judge sometimes may not have time to overrule the stenographer and signs the judgment. This is the process of law. So therefore, the output of a judgment is normally has a very short shelf life. Even the 9 judges benches of Supreme Court, modern judgments don't have a shelf life beyond 5 years. The reason is because of this. Therefore, when you use language, have a great precision. Use only that particular word should be used. So what happens in a courtroom? The imperfections of all these things that I mentioned, the pre-legislative paradigms, they are refined in the courtroom and a particular language is used. If you are a part of the problem and not part of the solution, that is, you create more confusion than the legislature has created in passing the legislation, then you are no longer a medicine. You are a virus sitting in a pharmaceutical company. Understand? So please inculcate the habit of using precise language. Thank you.
Much obliged, Honorable Court.
60 seconds.
The question, the rebuttals asked. Indeed, Your Lordship. Your Lordship, firstly, just because the UCC recognizes the customary practices as well as the religious practices, it does not mean that the aim of UCC has not been fulfilled. It still standardizes the personal laws. Secondly, Your Lordship, the Union Minister, by stating that it may provide exemption to the to recognize the customary practices of tribal communities, does not mean that it creates a confusion within the UCC. It at least it further solidifies the government's intent to spread the welfare, because the ultimate aim of the government is welfare of the state, and it will look into the welfare of all the citizens of the country. And thirdly, the counsel for the petitioner said contended that they contended that Mackenzie is the legitimate wife, but the respondents have also contended and proved that Sarah Sema should be entitled to the compensation and compassionate appointment, and further it is the judge's discretion to further give a judgment in this regard. Much obliged, Your Lordship.
Shall we adjourn, sir?
Observed.
Want to complete the evaluation here itself or will go? Yeah. Where is it? I have to tell you this. Right. Good job, sir. Okay.